Good morning. This is Immigration Attorney William Kovatch, and today we're going to talk about what to expect when you go to immigration court. Now, when you go to immigration court, there are two types of immigration hearings. There is the master calendar hearing, and then there is the individual merits hearing. At the master calendar hearing, before you arrive, you should be issued a piece of paper which is called a notice to appear. Now, the point of the notice to appear is to give you notice, essentially, of the charges that they're filing against you. It will have a factual section where it will list facts that the government believes proves that you may be removable. It could say, for example, where you're from, the fact that you're not from the United States, the fact that you don't have a visa to be in the United States when you entered the United States. And then the second part of it is the legal conclusion, the conclusion that will cite the type of law, the section of the code that tells us why you are removable from the United States. Now, when you get to your first hearing, the immigration court master calendar hearing, the point of the hearing is to address the notice to appear. Now, often you'll arrive at court, you may not, it may be the first time you come to court and you may not have an attorney with you. For the most part, the immigration judges are going to allow you to have at least one continuance to try to find an immigration attorney to help you. But when you get there after a second time, generally they're going to ask you to go forward and to plead onto the notice of appear. What does pleading mean? Well, pleading means you get the notice of appear and you either admit or deny the factual allegations, and then you either concede or deny the legal conclusion on whether or not you are removable. And you may need to have an attorney look at the legal conclusion to make sure that you don't fall into any traps. I mean, it's one thing to admit that you're present in the United States without a visa. It's another thing if you are admitting that you are likely to become a public charge, because that all sets the tone for what the case is going to be about. Once you've pled to the facts and to the conclusions of law, the next thing you do is you inform the judge of what country you are likely to be removed to. If you are removed, what country they would send you to. This, again, is another one of those times when you need to be careful about what you say, because if you are claiming asylum as your relief, you need to make sure you respectfully tell the judge that you are declining to designate your country of removal. Once you've designated your country removal, or once you've declined to designate it, the next thing you do is you tell the judge what type of immigration relief you are looking for. It could be, for example, as I said, you're applying for asylum. You fear going back to your home country because of persecution. And you're simply telling the judge, I wish to file an asylum application. I wish to file an I-589, which is the form that you use to apply for asylum. Perhaps it's cancellation of removal. Maybe it's some other form of relief, and you tell the judge. If you don't have a form of relief, this is the time when the judge will likely issue either a removal order or will ask you and the attorney for the government whether you qualify for voluntary departure. Voluntary departure is just a way to return to your home country at your own expense without the government paying for it, and the benefit of that is that you don't have a deportation order or a removal order on your record. So that's the first type of hearing. Once you've told the judge, or once your attorney has told the judge what type of relief you are seeking, then the judge will open up his calendar. Now, this is all done by computer, so it's a virtually opening up his calendar, but everyone else will open up their calendar, and then the judge will set the individual merits hearing. They will choose a date for you to come to court in order to present your case, in order to testify to the judge why you should stay in the United States. Now, here I practice in Northern Virginia. My court is the Arlington Immigration Court. Even with the new judges, and they've been putting in a lot of new judges recently, even with the new judges, what I'm finding is that it's taking about 2 years between the master calendar hearing and the hearing on the merits. So they'll set the hearing. It's likely to be about 2 years in the future. Some judges are even setting them out further because they have a really crowded docket here in Virginia. And the thing to remember about that is, number one, You need to make sure that you're practicing. You need to make sure that you sit down with your attorney and that you go over what your testimony is going to be so that there are no surprises. The other thing is, once you've set the date in the future for the merits hearing, for the individual merits hearing, you also need to make sure that you're looking at the documents you need to submit in support of your application. The deadline for filing all documents in support of your application will be 15 days before the merits hearing. So you need to make sure that you're not only remembering when the merits hearing is, not only remembering when the deadline is, but taking into consideration what kind of documentation you need in order to support your application so that you give yourself enough time in order to submit them before your merits hearing. And then, of course, your merits hearing is where you testify. You have an opportunity to testify through questioning from your attorney. You should have, by this point, at the master calendar hearing, you should have told the judge what your best language is. So if you're not a native English speaker, if you're a native Spanish speaker or a native Urdu speaker or any other language, you're telling the judge at the master calendar so that the government can provide an interpreter for you, although sometimes the interpreter is there by telephone, but then they can provide the interpreter for you so that you can testify in your native language. If you are going to have an interpreter, you do need to make sure that you speak with your attorney and practice, because working through an interpreter sometimes is difficult. Or you may be very excited about what you want to say and get it out really quickly, but when you're working with an interpreter, it's generally better to go in short sentences in order to allow the interpreter time to properly translate what you've said. Now, once you've got to the merits hearing, not only will your attorney ask you questions, then the government attorney may ask you questions. The government attorney is doing a cross-examination where they're looking into your credibility, so those questions may seem tough to you. And even the judge on occasion can ask you questions. And I've had several times when the judge has needed to clarify certain things and ask questions. Typically, at the end of the merits hearing, the judge is going to issue a decision. Doesn't always happen. Sometimes the judge wants to go back and consider it and write up a written decision. But typically, at the end of the merits hearing, the judge is going to deliver an oral decision on whether or not they're granting your application for relief. And if it is denied, then that date sets the time limit, sets the 30-day deadline for you to file an appeals with the Board of Immigration Appeals. Okay, I hope you found this video useful. If you like it, please give me a thumbs up, leave comments below, and if you'd like to see more videos like this in the future, by all means, please subscribe to my channel. This is William Kovatch. If you have any other immigration questions, or if you'd like to come see me for an appointment, please give me a call at 703-837-8832. Thank you.